In 2021, Anthony Plumb, a recluse retiree living in a motorhome, took in 27-year-old homeless veteran Zane McDonald, who was battling addiction. McDonald told friends he planned to blackmail Plumb and that Plumb had made unwanted sexual advances towards him. On April 20th, Plumb was found deceased in his motorhome, and it was clear he had been robbed. McDonald admitted to being there that night but claimed self-defense, alleging Plumb tried to assault him. However, investigators found Plumb's safe emptied, McDonald's fingerprint on the door handle, and his DNA in Plumb's mouth. Plumb's debit card had been used after his death. McDonald was soon arrested. He attempted to escape custody but was quickly recaptured. The evidence suggested premeditation and financial motivation. He was convicted. Now, Mr. McDonald appeals his conviction, arguing there was not enough evidence to prove he intended to commit robbery prior to the passing, and therefore his conviction should be overturned. He also challenges the deadly weapon enhancement, claiming the trial court erred by not providing the jury with proper instruction defining the elements of a deadly weapon. Additionally, he contends that his defense attorney was ineffective for failing to renew a motion to sever the charges at the close of evidence. Let's take a look at the arguments.
It's Laura Chuang for Zane McDonald, the appellant. We ask this court reverse Mr. McDonald's conviction for first-degree felony murder on the basis of insufficient evidence and reverse the deadly weapon enhancements because the trial court failed to read aloud the jury instructions. We also ask the court to reverse and remand for a new trial based on the remaining issues. I'd like to start with addressing the first issue in our opening brief, which is the sufficiency of the evidence on count one.
Let me start with a bunch of questions for you, Mr. Long.
Of course.
Did the state need to prove that Mr. McDonald formed the intent to rob Mr. Plumb before the killing?
Yes, Your Honor, that's exactly what we are arguing.
Okay, did the state need to prove that Mr. McDonald formed the intent to rob Mr. Plumb before Mr. McDonald entered the motorhome?
I don't know if that's a really good question. I haven't thought about that. I think that when you look at the evidence, though, that's not proven here. Either way, it's not proven that Mr. McDonald intended to rob Mr. Plumb before the homicide occurred.
Okay, and I'm thinking that the basis for felony murder was robbery rather than burglary. Is that correct?
Yeah.
So it was immaterial of the intent when he entered the motorhome. Would that also be correct?
I'm sorry, I'm not sure I understand your question.
Because they're not basing felony murder on a burglary, Mr. McDonald's intent when he entered the motorhome would be irrelevant.
I think I'm getting a little lost because it was charged as based on robbery.
Yes.
And so I don't know where the intent for burglary would.
And that's what I'm saying, that would be irrelevant.
Yes, I think so. Here, the state presented evidence at trial, or excuse me, that's not where I'm going to start. But as we're addressing, chronology is important in proving that a murder was committed in the course of a felony. But here, the state presented evidence at trial. There was a homicide and missing property, but the state failed to prove a chronology of events required to establish felony murder. The state did not and could not show Mr. Plumb's death was the probable consequence of second-degree or attempted second-degree robbery. As Irby states, it's not sufficient to merely show the killing and the felony were part of the same transaction. The state has to show the death was a probable consequence of the felony and must specifically prove that the felony began before the killing. As the court's aware, in a claim of sufficiency of evidence, the courts must consider the evidence of light most favorable to the state and determine whether any rational trier of fact could have found guilt beyond a reasonable doubt. Inferences based on circumstantial evidence must be reasonable, cannot be based on speculation, guess, or conjecture. And the danger here is speculating as to what the intent was beforehand in this case. There's a lot of evidence that's missing to establish a chronology of events. And when you compare this case to some of the other cases, in some of the other case law, especially in particular Irby, we're missing things like a forced entry, Mr. McDonald brought a weighted blanket and a toothbrush to Mr. Plumb's motorhome. Mr. McDonald, it's a little unclear what the relationship was between the two men, but Mr. McDonald's semen was found in Mr. Plumb's mouth, and Mr. Plumb was known to be bisexual. These facts don't show that he was unwelcome in Mr. Plumb's motorhome. Witnesses knew Mr. McDonald planned to go to Mr. Plumb's motorhome that night and was actually hesitant to go. Testimony showed that Mr. McDonald didn't bring any weapons with him when he appeared at the motorhome. These just don't establish any intent to rob. It doesn't establish an intent to conceal anything. Those all indicate that Mr. McDonald didn't have an intent to rob Mr. Plumb.
Yeah. Good. Counsel, he had a key, so there would be no need for forced entry, correct?
That is evidence that is in the. I don't actually know. I can't remember if specifically Mr. McDonald was given a key. I think he did testify to that, but at the same time, despite that, I think we have to look at what else happened that night.
Well, and let me ask some additional questions. Witnesses knew that he was going to go over there because there was those two ladies that he was smoking fentanyl with, and he had some discussions with them. Mm-hmm. Similarly, the differences in the height and weight between Mr. McDonald and Mr. Plumb, that was all evidence that was put in front of the jury. Couldn't a reasonable jury take that circumstantial evidence and say, you know what, we think that this person entered the Winnebago with the plan to rob?
I don't think you can just base it off of a person's size. I think you need more than that. You have to have the intent. And that's something that was laid out in the jury instructions as well. There are a lot of bad facts here, of course. There's property that's missing, but at the same time, there's nothing to show that but at the same time, if you compare it to Irby, property was missing there as well. And the court reversed for insufficient evidence because the court said, well, the intent wasn't the intent to steal that property before the murder wasn't proven.
Let me ask you something. Let's, another possible scenario here is that McDonald went to the trailer, Mr. Plumb was in there, they get into some kind of argument, disagreement, or something like that. In the process, McDonald kills Plumb and then thinks, okay, I've killed him, I'm out of here. Oh, by the way, there's a safe full of money, I'm going to grab the money and run. Would that satisfy the charges in this case?
No, it wouldn't.
Okay.
And that's exactly the problem here, is that's a reasonable interpretation based on what evidence was presented.
So even though you've got a dead body and you've got missing property, it wouldn't satisfy, the evidence is insufficient unless the state can show no, he intended to take the money first, and in the process of trying to take the money, kill the person.
Yes.
That's what they have to show.
Yes, Your Honor. That's exactly.
Could it be said that taking the money under Judge Staub's scenario was in the course of the killing?
No, because, if he killed someone and then took the money, is that what you're saying?
Immediately thereafter.
Immediately. Not unless the intent was formed beforehand.
You're saying that's critical.
Yes, it is. It is critical. And that's something that is specifically, if you look at State versus Vasquez, we can't infer intent. I don't know if the court's familiar with that case, but it's something I cited in my opening brief. And that was I think when I think about intent, I think about like looking at that case because there the court had sufficiency argument based on forgery. There were 2 fake IDs that were found on the defendant, and the court said that alone is not enough to prove that the defendant intended to defraud or to injure or defraud, just those things alone. So they reversed the forgery convictions on that basis. And I think that the danger here is that we're trying to infer, you know, and this is what happened is that the jury had to infer what happened first. And when you have speculation and it's equivocal, we just can't uphold a conviction on two possible scenarios.
Let me ask you something before we run out of time here, just because I wanted to ask about the jury instruction error. There was assuming that it's a manifest constitutional error to fail to read, we still have to go through the constitutional harmless error analysis, correct?
You know, I think that I will say that some of the standards on this are a little confusing when it comes to how to prove that. But I do think, you know, history has shown, and there's Ninth Circuit case law to prove this, that it is constitutional error to fail to read that jury instruction aloud. It's an omission. Sure. It's as if it never happened. We can't presume that the jury actually read the instructions. So
sure.
Here.
But even in cases where we've actually omitted an element, there's still the constitutional harmless error analysis. I mean, this court still looks at prejudice in that sense.
Yes.
It's not structural.
Well, and you're right. It's not structural, but the thing to remember here is the burden of proof was never read, and that is a requirement of this instruction. That I think it's Tongate requires that. Also, despite the fact that, you know, Mr. McDonald may have said he was holding a knife, the problem with that is you can't just, and again, it's also about inference. You can't just infer a conviction because a jury instruction was omitted. We can't just find someone guilty without a jury being properly instructed.
So, and then one of the other questions that I had, one of the assignments of errors alleges a discovery violation with respect to evidence of a criminal association between, is it Edie and Mr. McDonald? And I think that what the defense counsel was trying to show at that point in time was that Edie was a third-party suspect, if I'm not mistaken.
Yes.
But then during trial, didn't McDonald abandon this defense when he testified that no, he killed Mr. Plumb in self-defense?
Well, no, I don't think he abandoned the defense, because when you look at, I'm going to try to find this, but when you consider defenses, defendants are allowed to present multiple defenses if they want, even if they're, you know, how incredible they might be. I don't think you can abandon that, but also I think the problem is at this point in the trial, that evidence had come out, and so how to address it is a problem, right? You have to maybe change trial strategy, and perhaps McDonald wouldn't have testified. You know, I mean, a lot of things might have happened differently if they'd had that evidence. Maybe he would have pled or taken a, you know, deal. Maybe a different defense would have been put forth, and that was taken away when the state didn't disclose all the evidence.
You're into your rebuttal time.
Okay, I'll reserve the remaining. Thank you.
Thank you. Good morning, Ms. Lundgren.
Good morning, Your Honors. May it please the court, Alexis Lundgren on behalf of the state. I'll just start out with the—
Lundgren,
yes,
would you outline or list for us the evidence that showed that Mr. McDonald formed the intent to take the money from the safe before the killing?
Yes, Your Honor. The state presented evidence that Mr. McDonald was homeless, unemployed, and needed $100 a day to support his drug habit prior to April 21st, when the murder occurred. On April 19th, which was the day that Ms. Delight drove Mr. McDonald to Mr. Plumb's house twice, Mr. McDonald also went to his mother's house to ask for money. Between visits, he told Miss Delight that night that he was upset with Plumb for touching him, and that he was insisting on Plumb giving him his RV, money, or possession of something, or McDonald would tell Zumwalt, who is the property owner that the RV was parked on, about Plumb's sexual orientation, which was something that Plumb kept, did not want to disclose to his friends or family. Plumb told Detective Bonnie during his first interview that Plumb would only hurt him if McDonald attempted to steal from Mr. Plumb. McDonald knew Plumb had a lot of money. Plumb was murdered April 21st in the morning. McDonald did not tell his mother when he spoke to her that morning that it was self-defense. The RV appeared ransacked, but there was no sign of entry. The safe was unlocked and empty. And on his arrest, McDonald had a key to Plumb's safe and the keys to the RV. There was evidence that Mr. Plumb was a security freak and would not have given those keys to anybody freely. Mr. McDonald's fingerprint was found on the handle to the safe, and Mr. McDonald was robbed of thousands of dollars of drugs around April 21st, after the last time he saw Mr. Plumb. That evidence is sufficient for a jury to find, given interpreting the evidence in the light most favorable to the state, a jury could find beyond a reasonable doubt that the purpose of the murder was to obtain that money. While there are alternative explanations for those facts, that's not the sufficiency of the evidence test. The state is not required to rule out every hypothesis except that of guilt beyond a reasonable doubt under Jackson v. Virginia. It's the jury's role to decide whether how to interpret conflicting evidence and what weight to give the evidence. I'd like to also discuss State v. Irby, because that's one that Mr. McDonald relies on consistently in supporting his argument that there's insufficient evidence. There was far less evidence in Irby. Irby involved a case where there was some type of known association between the defendant and the victim around the days of the murder. And then when the murder was discovered several days afterward, the victim was found in a shop murdered, and there was evidence that his bedroom in the separate house had been forced open and his gun stolen. There was no other evidence at all of intent, motive, anything. Here we have a lot more evidence. There is far more than just motive evidence. Motive evidence would be, I need money. Mr. McDonald said that he was going to disclose this sexual relationship that Plumb didn't want disclosed if he didn't get money. He actually acted or expressed an intent to get money. And he told Detective Bonney that Plumb wouldn't hurt him unless he attempted to steal from him, which suggests there's some concern about that in the relationship. So that is sufficient evidence for the jury to, yes, Your Honor.
Let me move on to a different subject.
Yes, Your Honor.
Did the state agree at the beginning of the trial not to present evidence of Zane McDonald's earlier contact with law enforcement?
Your Honor, I think you're referring to motion in limine number 8. That motion in limine is intended to prevent police from saying that they recognize Mr. McDonald from prior contacts. That's not the purpose of what the state introduced this evidence for. And it wasn't that the police recognized Mr. McDonald from prior contacts. We don't even know who the police officers were that logged this information about this loose association. I don't believe
hearsay, wasn't it?
Pardon, Your Honor?
The evidence of this alleged criminal association was hearsay.
I don't know, Your Honor. If I'm remembering correctly, the objection at the time was hearsay, but that's not the argument that's being raised on appeal. This wasn't a motion in limine violation, and it was impeachment evidence. It wasn't offered, I don't think, to show that. Well, perhaps it was offered for the truth of the matter asserted. But regardless, that's not.
We can move on to a different area.
Yes, Your Honor.
Does a good prosecutor wish to know both the harmful evidence to the state's case and the helpful evidence to the state's case before trial, so that the prosecutor can better prepare for trial?
Yes, Your Honor. And I think here.
And should the defense counsel know before the beginning of trial both the harmful evidence and the helpful evidence in order to prepare for trial?
Yes, I think defense attorneys obviously have a duty to investigate and be prepared. Prosecutors, should know.
And how would the trial defense attorney know in advance this alleged log somewhere in the police department that there's a criminal association between Mr. McDonald and Mr. Eddy?
Yeah, and let me start by just saying I'd like to, I argued in my brief that it was not properly preserved under 4.7, that first prong under 4.7. I think that opposing counsel made a good point that I think the court was.
Pardon me?
I do think that the court recognized that they were talking about that first subsection under 4.7 and not just the one under 3. That's the evidence that tends to negate. So I just like to withdraw my preservation argument on that point.
Thank you for doing that.
Yes. I think it is important though that they show specifically what the violation is. So if you look at the language of 4.7A1A, it says that the prosecutor is to disclose the names and addresses of the persons whom the prosecuting attorney intends to call as witnesses at the hearing, together with any written or recorded statements and the substance of any oral statements. It's my understanding that the argument is that this is considered an oral statement of Detective Bonney. I'm not sure that this rule is talking about that. I don't think there's any way that the state could produce all of the oral statements that the lead detective.
Was there any oral statement by Officer Bonney in advance about criminal association?
Not that I am aware of, Your Honor. So,
and is the state arguing for that reason that CRR 4.7A1 does not apply?
Yes, because the state provided all the written documentation. I think it was 30 or 25 reports that were 30 pages long of the lead detective and provided the contact information. It's the state's position that that provision is intended to put the defense on notice of the individuals that defense needs to interview that will be presenting its case, and the gist of their testimony. The state never intended to introduce this evidence. And if you look at the record, the state expressed surprise that the defense was going down this route and only raised this on redirect examination after the defense had gone through this discussion of the check. I don't know that this provision requires an officer to write down every single part of his investigation. And so for that reason, I think that the trial court was not wrong in saying that the best way to get information that's particularly relevant to the defense's theory, which may not be something that the state is fully aware of, is to interview the detective about those circumstances. And the state certainly did provide information that Detective Bonney had done an extensive amount of research into Chase Eddy's bank accounts to exclude him, and had determined that he was excluded as a witness. But even if this court doesn't agree with me on that point, I think you still look to, did the trial court abuse its discretion in denying dismissal or mistrial? And then you look at this really wasn't particularly prejudicial to the defense theory. The defense was still able, and they actually did argue in closing argument, that Mr. McDonald committed the murder, and thereafter Mr. Eddy and robbed the RV of that money. And it's not really credible that they would have changed that theory, because I think the strongest evidence to poke holes in the state's case and to show a reasonable doubt is to say Chase Eddy deposited this check 2 days after the murder on the day that the body was found.
Okay, let me move on to another area. Do we need to disregard the Sanchez decision in order to rule in favor of the state on the question related to failure to read jury instruction 40.
Your Honor, did you say disregard the
Yes.
Sanchez?
Can we issue a ruling in this case consistent with the Sanchez decision, which ruling is in favor of the state?
You know, Your Honor, I'm not remembering at the moment whether Sanchez was objected to or not, and so whether it was an issue of issue preservation and manifest constitutional error. I would say that
it was.
Okay. I don't know, Your Honor. I don't think so. However,
so if we follow Sanchez, then Mr. McDonald should win.
I believe that is the holding of Sanchez, Your Honor.
Why should we disregard Sanchez?
I think Sanchez goes or stands in conflict with the Supreme Court precedent, State v. Jasper, which says that the court will not assume facts that are not in the record in order to reverse a conviction. The idea that jurors are illiterate is not a reasonable assumption. I know that co-counsel has cited the national average, but there's a survey in Washington State on the Washington Court website that talks about Spokane County, and 92% of jurors in Spokane County have a high school or GED or education above that. It's unlikely that the jury is going to hear the court's instructions and retain enough information from hearing these complex legal instructions that they'll rely on that oral recitation from the judge to determine guilt or innocence. The jury here, I think, deliberated for several days. I think it's reasonable to expect that the jury is going to be looking through all of the written packets. They received the written packets.
Ms. Lundgren, let me ask you a similar question. Even if we get through the manifest constitutional error issue, don't we still have to determine prejudice? I mean, that's where it seemed like in Sanchez, they just said, oh, there's error, reverse. And nobody went through the prejudice analysis.
Yes. So yes, it's not structural error. You still need to go through the harmless error. And I think maybe that's kind of part of the component I'm talking about, is that how is this prejudicial? You also have the only standard or a burden of proof listed in any of the instructions is beyond a reasonable doubt. They had to find beyond a reasonable doubt that it was a deadly weapon. Mr. McDonald admitted it was a deadly weapon essentially in order to argue that he could act in self-defense and kill somebody in response to being threatened with that knife. Mr. Plumb ended up dead as a result of the knife. It's per se a deadly weapon. So yes, I don't think that reversal would be appropriate on that. And I see my time is up, Your Honors, unless you have any other questions.
I have one more.
Yes, Your Honor.
I'm curious, did the Superior Court vacate the conviction for second-degree murder because of the conviction for first-degree murder?
Yes, to avoid double jeopardy, Your Honor.
Thank you.
Yes. Thank you, Your Honor. I'd ask that the court affirm, but remand for striking the LL host.
Thank you. Appreciate it. Ms. Swan?
Thank you, Your Honors.
Mr. Wong, under which section or subsection of Criminal Rule 4.7a does Mr. McDonald rely in this appeal? Both 1 and 2?
Hold on, I apologize. I'd like to pull the rule up. Yes, and I think that one thing I wanted, Mr. McDonald relies on the entirety of 4.7. There's always, there's a lot of other things. There are a lot of other things in there, like the continuing obligation to disclose evidence. But
Is there an obligation to disclose inculpatory evidence if that's not contained in a specific witness statement?
Yes, but I would dispute whether it was not contained in a specific witness statement, because if you compare this case to State versus Otten, in that situation, the witness who was going to testify realized in the middle of trial that there was some additional information that he didn't tell the state. He told the state, and it was evidence that directly went against the defendant's defense theory. And despite the fact that it was a statement that was made by that witness to the state, the court still found that should have been disclosed.
Did Mr. McDonald open the door for evidence of criminal association with Mr. Eddy?
I think I wouldn't deny that there's some possibility there. I think the problem, though, is that to begin with, Mr. McDonald had to have known about that evidence, and it wasn't disclosed. So I don't even think we can really get to the opening the door question, because it's kind of a hollow argument to say that, well, you opened the door to this evidence, but at the same time, you couldn't have known about it because we didn't disclose it. I think that's where that kind of negates the opening the door analysis.
Did Mr. McDonald testify that he used a knife in self-defense to kill Mr. Plumb?
Yes, he did.
So did Mr. McDonald concede that he used a deadly weapon to kill Mr. Plumb?
No, because I think the problem is, again, we don't have a proper instruction of the jury. And I did want to talk about the illiteracy issue.
But didn't he obviously concede that he used a deadly weapon?
Yes.
And does that defeat the argument that jury instruction 40 was needed, and therefore there's no prejudice to Mr. McDonald?
No, because I think there are a lot of statements that could be made on the stand that, someone could admit to a crime of some sort, but if the state hasn't charged that crime, we're asking the jury to find guilt when we don't have that. When we don't have a jury instruction supporting it. Is that
okay?
Yeah.
And I think you were getting towards this, is being able to read English a qualification for being a juror?
No, it's not. And the other thing about that is that when you look at Sanchez, it specifically says it's not just about whether a jury might be illiterate, it's also about whether the jury actually read the instructions. And those were two considerations. It wasn't just whether a juror might be illiterate. I see my time is up, but we asked for the relief we requested in our opening brief. Thank you.
Following these arguments, the court affirmed Zane McDonald's convictions. They did, however, remand the trial court to strike the victim penalty assessment and the DNA collection fee. Please, let me know what you think about this case in the comments below. And if you like this video, please hit subscribe for more arguments every week.